doctrinaire about its being integrated public education, but until very late, really, he argued that that it was not an injustice to blacks to have a black school on one corner and a white school on the other corner, as long as both, in fact, received equal funding and the education truly was equal. He was very aware of what was necessary to make the education equal. He was not committed to segregation, but he didn't want fighting for integration to interfere with there being public schools at all.
I would just add briefly to that, with the 1868 convention, Tourget and others saw it as a scare tactic that was being used by what were called then the conservatives to say that the Constitution, they're trying to make it require integrated schools. And so Tourget and others were saying, no, you don't buy into this fear thing. We're just seeking equality. So I think that they were very attuned to just those kind of fear tactics that were being used at the time. Yeah.
I have a question for the judge about Judge Tourget's, the quality of his thinking and writing as a jurist. You've mentioned already the sort of forward-thinking emphasis on state constitution is where rights have to be protected, not just relying on federal constitution, and then fast-forwarding his seemed to be pretty early willingness to use broad, even sociological evidence, so they wouldn't have called it that in the Plessy briefs. But as a Superior Court judge, how did he try to apply the law as a kind of living, breathing thing in real decisions? Was he I don't know. You don't use the modern term of an activist judge, but in his rulings as a Superior Court judge, did he bring in the context that was going on around him, or was he just ruling on the law as it was?
Well, there's not a lot of, there may be a record in Guilford County that I haven't examined yet, but I've read a lot of his appellate appeals from Judge Tourget's things, and most of the law at that time isn't as exciting as it is now. We're dealing with, I mean, after the Civil War, property rights and property disputes are by far and large the largest quantity of what is taking place in North Carolina. And so the homestead exemption becomes terribly, terribly important to ensure that people get a house that they can live in, and $1,000 at that time, or whatever the amount was at that time, was a very important right to make sure that the 70% of the people that need to have a farm and a home didn't have it taken for debt. So that was one thing, and that applied without regard to race. And that was very important to say non-slave owning Piedmont yeomen in Guilford County and elsewhere, because most of the slaves were located in eastern North Carolina. So the homestead exemption and that sort of thing becomes very important. When one says an activist judge, a Superior Court judge could convene a grand jury at that time and get indictments against, and try to assist in getting indictments against Klansmen, and that's what he did. So that's a very activist thing for him to do, and in addition to which he would punish and